Hello, and welcome to episode 16 of Privacy Laws, where I, Donata Strong-Skilbridge, speak with amazing privacy professionals, and we have some laughs along the way as well. This podcast is brought to you by Termageddon, an auto-updating privacy policy generator. Today, I'll be speaking with Jason Kelly about one of the hottest topics in privacy, businesses being sued for website tracking under the California Invasion of Privacy Act. Jason is a partner at Annaguey McCann and a litigator that uses his experience in complex commercial disputes to help companies of all sizes resolve disruptive lawsuits and find pragmatic solutions aligned with their goals. Jason litigates claims of fraud, breach of contract, anti-competitive behavior, and more. Jason is also a certified information privacy professional and has helped clients respond to and litigate claims of CIPA violations. So, Jason, thank you so much for joining me today. What made you interested in representing businesses in privacy disputes?
Well, thank you for having me. It's a pleasure to be here. My interest in representing privacy businesses rather than privacy disputes really just kind of gradually changed over time. My background is working as a general civil litigation attorney. Just being a generalist. But I have a lot of friends and family who work in tech, and they've been talking about privacy and data issues, and especially back when GDPR was first coming out. So it's always been something that's been interesting to me. And it's an exciting area of law just because it is so cutting edge. There's a lot of new issues, new laws developing right now, like just all over the US and internationally. So it's a really exciting time to be in this space.
It is a really fun field because, like you said, there's something always happening. There's really no shortage of things to be reading or looking into, which I think makes it kind of fun. I mean, there's other areas where the law has been settled for a really long time and it's kind of litigating and relitigating the same issues and the same laws. So this is a lot more interesting than that, I think.
Yeah, it definitely is. I mean, yeah, I think you're right. Like we're used to reading these cases and having this doctrine that's been around for hundreds of years, or cases where you're citing and saying, well, the Supreme Court decided 95 years ago, this or that. But today, it's almost feels like watching a telenovela or like a soap opera, where it's just this thing's happening over here and they're threatening this, and then they didn't meet the deadline, so this new regulation is not going to go into effect. Oh, but look, maybe Congress is going to get its act together and we're going to have all this change. Oh wait, that's not going to happen. And every day it's just these new alerts come in, and you're just kind of like, you're trying to keep up with it, but it's also like sometimes it's noise, and yeah, it's fascinating. And I find myself just reading a bunch of these like alerts and updates and notices that pop up. So it's definitely different compared to other areas of law.
Yeah, absolutely. So you initially started in business litigation, do matters like antitrust and fraud. How did you start representing businesses in privacy disputes? And do you have any advice for other attorneys who want to pivot into privacy?
Yeah, my pivot into privacy was a pretty gradual process. I started out at a large firm, and I worked at a number of different firms where we were doing a lot of these like contracts or fraud or like antitrust cases and class actions, and I really enjoyed it. It was exciting. It's fun as a litigator, but privacy litigation was something that I was interested in, and I think there were two things that kind of helped me pivot into that. And one was just like my interest, like I mentioned before, just trying to keep up with what's going on and being curious about what's happening and how this tech is applying to all of us, and what does that mean from a legal standpoint. And then the other thing was I started working at a firm where I had an opportunity to explore that area of law, rather than just being told, we don't have a practice group that does that, we're not interested in you trying to develop anything like that, just keep doing what we're doing now. So, you know, it having that opportunity to explore that and having people that you work with who are supportive of that, I think is massive. And I think that would just be my biggest piece of advice is, if it's something that you're interested in, whether it's your company time or your personal time, like be curious and like make an effort to learn about these things, like find out what's happening, whether it's at a firm, business, or a government agency. Just try to go out there and learn more and put yourself in a position where you'll have those opportunities. And it might take a little bit of time, and that's fine. But if it's really something you're interested in, like pursue it.
Yeah, it's really interesting because, great example of this, when I went to law school, there were no privacy law classes. That was not a thing. Neither were cybersecurity courses. But now a lot more law schools are offering those courses for law students who are interested in these areas. And I think it's the same way with law firms, right? It's something that law firms haven't necessarily thought about this, for a long time, but it's definitely coming up as a question that clients ask about, that lawyers are interested in. So I think we're going to see more and more law firms have privacy law departments.
Yeah, and I think before you would see a lot of, emphasis on compliance, and then if there were, litigation issues, it'd be focused on like a data breach.
Mhm.
Those were kind of like the big umbrellas or big kind of like buckets that people would fall into if they're in litigation, but it's changing. And now you have a lot of people who are moving into the space because they're interested, and there I think there will be more opportunities. And so, the big thing is just pursue those opportunities and keep your eyes open because they're out there.
Absolutely. So we see more and more businesses getting sued for privacy violations, which is a relatively new development. Do you find education to be a big part of your work? How do you educate your clients on why they're being sued?
Yeah, education's massive. It's a real big thing, and I think a big part of it is just the fact that the types of companies that are now being targeted, a lot of times they're not companies that have a history of litigation or have these massive in-house legal departments. I'm even finding a lot of times the people I'm talking to, like they're small businesses that have, one, two, maybe three employees, and they've never had to deal with legal issues besides
Mhm.
maybe like drafting or entering into a contract. So a big part of my process is really just teaching them about what litigation is, what litigation in California is like, and how the whole process works. Like one of the first questions I'll typically ask is just, have you dealt with a lawsuit before besides like a jaywalking ticket, or I got into a car accident when I was 16? Because knowing their history and their litigation background will help me provide a better service and give them context as to what's happening here in California, this area of law, and why they got this letter or this lawsuit that was this filed. One of the things I'll also tell them is just give them context about the fact that they've essentially been caught up in a massive wave of litigation, and it's hitting a lot of different people all at once. And it's not like, this business did something specifically wrong and that's why they're being targeted. So, it's that education, but it's also just learning from them, trying to learn about what their goals are, and so that we can find, the most efficient way of resolving this dispute, these allegations.
That's very true. I mean, we've heard of businesses getting sued under CIPA and get on a call with them. They're like, but everybody uses the Metapixel. Why are they going after me? And, I'm a small business and I don't have this much money. Wouldn't they go after somebody who has more money? And I think you're right that this is just a wave of litigation that everybody's getting so caught up with. But if you've never been experienced in litigation, it definitely feels scary and it's a lot different. As a lawyer, you do have stakes in it. You have a client that you have to represent, but it's a lot different when you're the one being sued versus when you're defending someone from a lawsuit.
Yeah, absolutely. That's absolutely what's going on, and that's the way that you've got to talk to these people, to kind of just let them know, what's happening to them, how they fit into like the bigger picture of what's happening.
Mhm.
One of the responses I'll get oftentimes is, "Well, I checked this law firm that sent me that, and I checked their system, and they're using this pixel, and they're using that pixel, and I think they're doing the exact same thing I'm doing. So like that's the initial reaction is just like, I'm not doing anything different or wrong, and I'm certainly not doing anything maliciously. So why am I getting picked on, and why am I being threatened with this legal action?
Mhm. Yeah, absolutely. So today we're going to be talking about the California Invasion of Privacy Act, which is a pretty old privacy law. Can you tell us a little bit of why this law was passed?
Yeah, so CIPA, California Invasion of Privacy Act, it's an old law. It goes all the way back to the Cold War era. It was enacted in 1967, you know, long before the internet existed. And it was primarily focused on telephone technology and communications. So CIPA is unique in the sense that it's a penal code statute. It's part of California's penal code. Like basically our criminal law here. And it was intended to protect Californians by stopping illegal eavesdropping and wiretapping on private communications and phone calls. It's a statute that has over time been amended. One amendment that will be, kind of the focus of a lot of our discussion, I think, today is this 2015 amendment that came through in a bill called AB number 929. It was passed and enacted in the law, and it's now part of the penal code. It's section 63851, and it's a provision that prohibits the installation or use of a thing called a pen register or a trap and trace device unless certain statutory requirements are satisfied.
So SIPA talks about communications between a resident of California and another party. So, what are some examples of a communication with a resident of California?
Yeah, traditionally, like I said, this is an old statute. You think back to like the 1960s, 70s. The communications that they were focused on were primarily just phone calls. Like we're talking like old school landlines.
Mhm.
But in the latest wave of CIPA litigation, what you're seeing is an expansion of that. And these plaintiffs are trying to expand the communications from just a phone call to a web browser or device accessing a website. That's the communication, is accessing a website versus calling another person.
This is pretty random, but thinking about landlines, it makes me think of phone parties where back in the day, people would just have one landline, one connection for the entire town. And then they would take turns making calls, and then people could eavesdrop on those calls. So it's really making me think of that, of way, 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 way back in history when an entire town had one phone line and everybody could listen in, but apparently we're not talking about that anymore.
Yeah, no, it reminds me of, back, like I'm thinking like middle school and high school, you would talk on the phone with your friend, but you would also go grab the other phones in the house to make sure, your little brother or your little sister doesn't like get on the phone and start making like, screaming noises in the phone, or your parents don't eavesdrop on your, call with your friend. And so I remember, seeing my brother, for instance, like talking on the phone and just holding like the other wireless phones in the house, like in his hand, just to make sure that I don't mess with them, kind of thing. But yeah, it's like that, but it's not. It's like that, but not.
Yeah. So I think with this amendment, now we're talking about pen registers and trap and trace devices. What are those?
So pen registers and trap and trace devices, they have a common definition, but in CIPA, the California legislature actually gave them statutory definitions, meaning like there's an actual definition in law for these two things. And so, for the lawyers out there, it's Penal Code Section 64850, subdivision B and C. But basically, a pen register, it's like a mechanical device that would actually record the numbers dialed from a telephone, but it doesn't overhear the communications or what's actually in that call. So if you think about, like, I always think about, like 1960s movies, like spy movies or law enforcement movies, and you've got the phone line of like the mobster, and the police want to find out who's this mobster calling or who's calling this mobster. What they would actually do is put a device on that line so that they could see what calls were being made to and from that line. So unlike a wiretap, which lets you listen into the conversation that's actually happening, like the contents of those communications, a pen register, and the same thing for a trap and trace device, they would let you know what phone numbers had called that number, and then like what numbers that phone number had called out to. So a trap and trace device records the originating telephone numbers of the calls dialed into that person, whereas a pen register would show what phone numbers were being called from that line.
Do you remember in the early 2000s and 2010s, you would get your phone bill and it would show you every single number that you've texted or
Yeah.
called?
Yeah.
That was fun.
Yeah, I exactly. And you could see everyone and, I remember being like on a family plan and then like, you're all sharing minutes and, it's like, what? You're spending all our minutes, Jason, like, what are you doing?
Yeah,
We're going to charge you extra or, we're going to have to change our plan because I can see how many times you're calling your girlfriend kind of thing, like in the
yeah.
middle of the night sort of thing.
Yeah, and they could also see the time. So they'd be like, "Well,
Yeah,
you told me that you were going to sleep, but you sent 200 text messages." And I remember parents being just absolutely flabbergasted by the amount of text messages that you could send. And looking back on it now, it was insane. Like, how could you
it
send
was.
that amount of text messages to anyone? I could never do that. I could never do that again. I don't think that's possible.
Well, what makes it even more like kind of mind-boggling is the fact that remember those phones like to like
Yeah.
send certain letters, you had to press the button multiple
Yes.
times. So it
Yes.
wasn't like a keyboard where, like so you're just like doing that nonstop, just, glued to it and sending out, SMS texts to your friends,
Yeah.
emojis and all that. Yeah.
That
But
was
it's
very
it's like
fun.
that. It shows like, what calls were made and how long those calls were and
Mhm.
like I said, it doesn't show the contents of the communication, but a pen register and a trap and trace device which show you, you know, who's calling you and who you're calling.
Yeah, absolutely. So, CIPA, it has a private right of action. Can you tell us, like, why is that significant and what type of damages can be awarded under CIPA?
Yeah, so private right of action is just a legal term for a person can sue for that violation, which is again kind of unique for CIPA because CIPA is in the penal code. So it's a penal code statute, meaning it's criminal, and typically only the government can prosecute a criminal violation. But CIPA has a unique provision in it that allows for a private right of action for certain types of claims. So a person doesn't have to report it to the police and hope that like the district attorney, for instance, prosecutes something. They can hire a civil litigator and file a civil lawsuit for certain violations of CIPA. So under CIPA, a private litigant is entitled to $5,000 per violation, or if they actually suffer damages, what they can do is they can treble those damages, meaning they get 3 times the amount of the damages. One thing that's outside of CIPA, but that you're seeing built into these CIPA lawsuits that are being filed in these demand letters, is a request or a demand for punitive damages, which are damages that are extra and they're intended not to compensate the victim or the plaintiff for the injury they suffered, but they're sums of money that are intended to actually punish the defendant. So you'll see that in these cases, the plaintiff will allege that the business acted with oppression and malice by allegedly installing the pen register and trap and trace device, and that they knowingly violated CIPA. So because it was malicious, the defendant should be punished even more. And so that's being added on as a potential damage.
Very interesting. So, we kinda talked about phones and landlines and people kind of, eavesdropping on those calls, but, how and why is this old privacy law being applied to modern websites?
Yeah, it's a creative move on these plaintiffs' part, and what they've been able to do is take this old statute, this old law involving an old technology, and they've been able to file lawsuits, threaten to file lawsuits, and in some cases get judges to agree that this old statute could apply to the internet. And essentially, they've been alleging that pixels or web beacons that companies use on their website that show the IP address of whoever is accessing the website, that those are effectively pen registers or trap and trace devices, and that they therefore violate CIPA, and that a plaintiff is entitled to $5,000 in statutory damages for each violation. So it's just a really an expansion that you know effectively could reach every single interaction that takes place on the internet.
Yeah. Are there, like, certain types of websites that are getting sued, or is it kind of all over the map?
It's really all over the map. It's surprising and striking how broad the group is. So you're seeing it hit these types of demands and these types of lawsuits hit every industry. You got marketing companies, entertainment companies, companies that work in e-commerce or fintech and banking. I just recently spoke to someone who works in a HR recruiting company, and they're getting these types of demands and letters, and it's massive companies like some of the biggest names that you'll see. You see a lot of these sort of like VC-backed tech companies that are also being hit. But then there's also these random small businesses that have these very, small websites that aren't doing, these massive sales, and they've maybe got one or two employees. So in the past week, for instance, I've spoken to people in London, New York, Florida, San Francisco, and Charlotte who have either received a letter or just recently got sued for a CIPA violation.
It's interesting because the first time I heard about these lawsuits, they were coming after kind of healthcare adjacent companies. So companies that are not hospitals or medical providers, but that do provide some kind of medical type of service. And initially I was like, okay, that makes sense. You don't want people who are collecting data on your health to be sharing that data with Facebook, for example, right? With the Facebook
Yeah.
pixel. And then it kind of exploded from there. It went from something that kind of made sense from a privacy perspective to, hey, I'm selling just trinkets and I'm getting sued. So it's very interesting to see this progression.
Yeah, it's almost I mean, it's kind of surprising. And it's one of those things where if you weren't watching it, happen in real time week after week and seeing the types of businesses that are getting hit, you might not believe it. But
Mhm.
sometimes you'll see like there's almost like a theme at times. Like you'll see like a week where certain businesses are getting hit and you're like, okay, like that was their week to go after those like online apps. And then like
Mhm.
2 weeks later, you'll notice that a bunch of companies that are in this other space are being hit with these types of lawsuits. And so it's it's just like you said, it's really exploded and it's all over the place.
I wonder if they have a hat full of papers that say each industry, and then they pull from the hat, and that's the industry they sue that week.
I actually was thinking about that, and I was able to confirm. No, I'm kidding. That it wasn't a hat, but it was a giant wheel. It was an old
Nice.
school wheel.
I
Yeah.
like that. I
Um,
like that a lot. So, are there certain types of website features that are leading to claims of violations of CIPA?
Yeah. So, I mean, we've been talking mostly about SIPA in the context of pen registers and trap and trace devices. That's really kind of become the thing today. But if you were to go back about a year and a half ago, the SIPA cases were really focused on an entirely different issue. They were primarily focused on chatbots. And what these plaintiffs would argue is that, I went on your website and I used the chatbot feature and I thought I was communicating with you, and I essentially was communicating with you. But my communication was essentially eavesdropped. It was like, someone was listening in, and the person listening in was the chatbot in the company that the vendor that provides the chatbot services. And so I didn't realize that my communication with you, website company, was going to be eavesdropped by this chatbot vendor. And so that was a violation of SIPA. And so you would see claims against the website operator saying you were involved with the eavesdrop, either directly or you were aiding and abetting.
Mhm.
So kind of going back to your question, the websites that were getting hit the most were ones that had chatbot features. But the tension now is like, again, moving towards pen registers and trap and trace devices. And so you're actually seeing that certain pixels or web beacons are getting hit or getting a lot more attention. The one that really stands out a lot is TikTok. If there's a
Mhm.
TikTok pixel, that's really at the center of a lot of these letters and these complaints. But also, pixels related to Meta are getting hit.
Very interesting. And how many of these lawsuits do you see? I mean, I know you track this stuff every day, and from our perspective, it seems like a lot, but it would be nice to have some kind of more concrete numbers if you have them as to how many of these lawsuits are getting filed.
Yeah, it's a lot. I mean, it's a lot and it's growing. If we were talking about a year, 2 years ago, I'd say you'd see complaints coming in every day. in federal court and state court in California. In LA, you'd see probably, maybe 2 or 3 lawsuits filed. And those are just the ones that get filed. So that means that maybe a letter went out beforehand, a settlement wasn't reached. And so this is actually like escalated to a full blown like lawsuit. That's gone up substantially. Like in LA alone, right now, you'll see dozens of lawsuits filed each week. It's pretty common to see on a given day anywhere from 5 to 10 complaints filed by a variety of different firms. Um, Another change related to that has happened is, about a year ago, maybe year and a half ago, you'd see a division. Certain firms would tend to file in federal court and other ones would file in state court. Now, the vast majority are filed in California state court. And so when these complaints come in, you'll see that some defendants try to remove them to federal court. It's a procedure that you can use where you say that this case that's in state court, it should be in federal court or can be in federal court because the federal court has jurisdiction. And certain attorneys, certain parties think that, they'd rather be in one court than another. And so, these defendants, these businesses will try to remove a case to federal court. Those efforts have generally, like more often than not, or very much more often than not, failed. And so they'll go to federal court. The federal court will look at it and say, like, no, we don't have jurisdiction over this. You need to go back into state court. So, yeah, just more lawsuits, primarily in state court. And there are more players now. About a year ago, there had been 1, 2 firms that were involved with this. They were doing all the filings. Now, I'd say they do the vast majority of the filings, but I'm like now seeing like, 5, 6 firms that are involved. One complaint I saw filed, I think it was a week or 2 ago. I was unfamiliar with the firm. I looked them up and it's a plaintiff's employment firm. They're all employment lawyers, but now they're suddenly getting into this game and they're, cool privacy lawyers. So I don't know. It's one of those things where, we may just be seeing like more and more of these jabronis kind of like getting in to this type of work.
Yeah, I mean it's a lucrative area, right? Because all you have to do is send some demand letters. Hopefully most of the people pay, you get paid. Hopefully most of the time you don't even have to go to court at all. It's kind of relatively easy paycheck for a lawyer, isn't it?
Yeah. I mean, it's you could call it an easy paycheck for a lawyer. I know a lot of people would call it, something like a shakedown, or they feel like it's a shakedown. But yeah, I mean, you see more people moving into the space, and I think
Yeah.
as this grows, that's something that you might expect to keep
Yeah.
happening.
Absolutely. So before a lawsuit is filed, so many businesses have received demand letters saying that they're violating CIPA. What do these letters look like and what are they demanding?
Yeah, their lawyers would call them pre-litigation demand letters or pre-litigation settlement letters. They're typically, in this context, I'm actually looking at one right now that was sent to a client. They're typically pretty short, 2 or 3 pages. They have a lot of kind of boilerplate language in there. I spoke to someone who is in-house at a marketing company who received one of these letters, and she said, "Yeah, we got this letter, and it looked like a scam, so we just ignored it." And then, fast forward a few months later, and suddenly we got sued. But generally, the structure of these letters are pretty similar. They'll say something like, "We represent, this person, and based on our investigation of your website, we think that you're violating CIPA." They'll emphasize how important privacy is and how, violations of privacy laws should be punished. And so, we investigated your website and we see that you're using a certain type of pixel or a certain type of web beacon that collects information. Sometimes they won't even say that. They'll just be very general and say there is a pixel or web beacon that we think is doing, this or collecting that. But they won't actually give you any specifics. Other times you'll see like a screenshot in the letter. And then they'll say something like, each violation is worth $5,000. And we think there are several violations. And we might sue you on behalf of our client, or we might turn this into a class action. You're going to be on the hook for a lot of money and, you really did a bad thing. But all that said, we're open to settling with you. And so sometimes the letter will say how much they're willing to settle for. Other times it will be silent, and they'll just say something effective, get back to us by X date. If you don't, then we'll sue you. And so that's typically the letter that you'll get. Sometimes it's by email, sometimes it's by the actual snail mail, but those are the letters that are going out there to these businesses.
It almost seems like some of these letters may be based on templates.
Oh yeah, they are. They will have a different name, who the letter is being sent to, but you can tell which firm sent which letters, and you can just put them next to each other and see it's just the same thing recycled over and over.
That seems really crazy to me. I mean, to be sending out that amount of demand letters and requesting that amount of money and using templated letters and reusing the same thing over and over again and suing small businesses that are not collecting like sensitive data. I don't know. That seems kind of wrong to me.
It's extreme. I'll say that. I'll put it nicely. I'll say it's extreme. But the crazier part for me is that's the letter. Like what you're talking about is just the letters.
Hmm.
The same approach is used for the actual complaints that are filed. So you'll look at complaints. If a given week you'll look at a complaint that was filed against all these companies, and you'll see that it's exactly the same allegations, same images, same structure, everything. It's just the name of the defendant has changed. And there was actually, I think it was last year, there was a federal judge involving CIPA that called out a plaintiff's firm and said that I'm looking at this and you're using very generic language, and it's very clear that you're copying and pasting the exact same thing
Hmm.
and just filing it against dozens and dozens of different businesses, and you're using the same 4 or 5 plaintiffs over and over. So they'll do that in the letters, but they'll also do it in the filings with the court.
Wait, so they use the same plaintiffs over and over again?
So if you
Oh,
if you get a demand letter and you can see who they're allegedly representing, if you Google that person and like the name of the attorney, oftentimes you'll see so many other lawsuits that were filed by the same plaintiff's firm on behalf of the same individual over and
wow.
over and over.
That's insane. So
Yeah.
when a business gets this letter, do they just pay the requested amount? I know some people may be tempted to ignore the letter. What happens if the business ignores the letter?
So the vast majority of businesses, I do think, end up paying something to resolve the case, whether that's the amount that's requested or they're able to negotiate down and get something that a lower amount, something that's more palatable. That's another thing. But I think the vast majority of businesses, when they get these, they're not happy. They don't think they did anything wrong, but they'll come to a business decision and realize like paying the money, getting this thing done, and not having this escalate into a lawsuit makes the most sense. But sometimes you'll see people who they ignore the letter, or they just don't want to respond, or they hope that it will go away. They'll do that, and they 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 take their chances. I've seen
Mhm.
instances where a letter was ignored and then a lawsuit filed shortly thereafter. And then I've talked to people who they got a letter, they ignored it, and then it was like months later, and they were kind of thinking, "Oh, this plaintiff's firm is like gone away. They've forgotten about me. I'm not a big player." And then they get surprised when a lawsuit's actually been filed. So that's a risk.
It's interesting. So for people who do want to, fight the lawsuit, what's the average approximate cost of this?
It's litigation, unfortunately, is expensive. Defending a CIPA lawsuit really is no different. A lawsuit like this can easily, the defense cost could easily go into the six figures, especially when you're talking about cases filed in Los Angeles Superior Court. The courts just, there's a lot of filings going in. The judges are overworked. There's a huge backlog. The state recently announced that they're cutting the budget of the courts again. And so, you'll have a lawsuit that gets filed, and it may take years for the case to ultimately, reach the end. And just filing a motion and trying to get in front of a judge, you have judges who aren't, they don't have a hearing date available for 2, 3, 6 months. So you get your papers, you file them, and then you just wait for a really long time. So even an initial challenge, like something called a motion to dismiss or a demur with the supporting papers to say that a complaint is, legally not viable, it should be kicked out before any type of discovery or exchange of evidence takes place. Like that can easily get into the $20,000 to $30,000 range. And then the other thing too is if your arguments are accepted, the court finds that, yeah, your motion to dismiss is granted. There's also the possibility that the court will say to the plaintiff, well, you know, do you want to try again? Do you want to fix your complaint and add more allegations or more specific information or do something to show that your case is viable? And almost always the plaintiff will say yes. And so then a new complaint, an amended complaint will be filed, and then you'll go through that again. So it can take a long time and be very costly.
Yeah, that definitely explains why a lot of businesses do end up settling with this, even though they don't agree with what's been alleged, because, it's really expensive to fight a lawsuit. But then it also doesn't seem like there's any true consensus in the courts either as to whether these lawsuits should be allowed to proceed or not. Is that right?
Yeah, I mean, going back a year and a half ago, this didn't exist. Like these types of cases, this case, the alleged violation of CIPA related to pen registers and track and trace devices. Like, no one filed a lawsuit based on it. And so now it's become this thing that's just all over the place. And so these complaints are coming in and judges are having to decide this stuff for the first time, and to figure out whether, this is legally viable or it's not. And one of the things that's been interesting, but actually quite frustrating, is just seeing judges reach contradictory or inconsistent decisions based on, again, a copy and pasted complaint. So, for example, in March, there was a case that was filed by one of these firms. It was a more or less a copied and pasted complaint, and the defendant filed a motion to dismiss or demur, trying to say this case, this shouldn't go forward. The alleged violation, the law, CIPA, it all concerns telephones and landlines, and it doesn't involve internet communications and IP addresses. And the court agreed with the defendant. The court said that CIPA is limited to telephonic devices, including cellular phones, but not internet connected devices with a unique IP address. And the court went through this long analysis and it looked at the fact that all the legislative updates and commentary was talking about a time when we were dealing with cordless and cellular phones, not internet-based communications. That was March 2024 in Los Angeles Superior Court. The next month, 3 weeks later, in April, in Los Angeles Superior Court with a different judge, the court denied the defendant's efforts to try to get the case dismissed and said that the CIPA statute generally, it was written in a way where it could apply to IP addresses and website traffic. And so at this point, the judge is not comfortable with just dismissing the case and he's going to let the case go forward. And in that order, the entire analysis was limited to just two short paragraphs. So you have these inconsistent, contradictory sort of rulings, and you've got it also not only in LA Superior Court, but in other state courts in California. And then you also have federal courts in California that are reaching similar or different types of results. And the fact that also you've got defendants who are making similar but different arguments. And so maybe one argument that was really persuasive to one judge, you'll notice that in another case, the defendant really didn't make that argument or didn't make it well. And so then the judge didn't, latch onto that. But it's just very fluid at this point, and it's giving, I think, some of these plaintiffs a lot of courage and other people who are interested in filing these lawsuits courage to think that, there's something there that they can essentially weaponize this law and use it against all sorts of, companies that have websites.
I think it's really wild that you can get two different judges in the same court decide the same issue in two different ways.
Yeah.
Yeah, I can't imagine how frustrating that is. And, in terms of putting things in a more persuasive way, Maybe the defense should follow the plaintiffs and copy and paste. I don't know.
No, you're right. It is really frustrating. And I mean, it's especially frustrating when you're talking to some of these businesses and they're saying, "We care about privacy. We don't want to do something wrong. We try to do what's right." But right now we're having trouble understanding in California what is right. Like, what are we allowed to do? And give us some guidance, give us some clarity so that we can do what we need to do. And that's, I think, the most troubling part because they're not trying to skirt the law. They're trying to understand what the law is and comply with it.
Yeah, and I mean, no offense to anybody listening to this who's from California, but that's kind of the California way is we'll pass a bunch of laws, we'll enforce some of them, not enforce others. And if you want any guidance, well, here's some comments from a public comment period that have nothing what to do with compliant with complying with the final text of the law. I mean, we've seen that time and time again where regulations conflict with the text of the law, the FAQs make no sense, or there's no resources really to help businesses understand how to comply, and then everybody's upset that the business is not complying. Well, if you're not explaining how to comply, what is the business supposed to do exactly?
Yeah, I mean, I get the frustration. And what's interesting is, you're talking about more, I think, in the regulatory compliance area where you have, agencies that are supposed to be specialized in certain areas of law and try to, regulate certain industries. But here what we have is just a law that was written in the 1960s and then amended by the California legislature, and they, have some records in the legislative history showing what the law is intended to do, what we want this law to accomplish, why we're passing this law. They pass the law, and then it just sits there. And
Mhm.
then now you've got courts, you've got judges who they're dealing with a breach of contract case here, they're dealing with a lemon law case here, and now they've got a CIPA case here, and then they'll take lunch, and then they've got a civil rights action, in the afternoon, and they've got a real estate dispute. Like, that's what we're kind of dealing with, and so
Yeah.
it can be extremely understandably frustrating for businesses who are getting caught up in this.
Do you think that, these demand letters and lawsuits will stop anytime soon?
No, I don't. I don't. I don't think they'll be slowing down anytime soon. They're picking up, and last I checked, there are a lot of websites on the internet, and so there are a lot of websites who can be targeted in these types of letters and these lawsuits. We're just seeing more and more of this, and the fact that we're seeing more and more firms get involved with this makes me think that it's going to become more commonplace. And we have a client, for instance, who they're dealing with one plaintiff's firm and then they're getting a letter from another one. So,
Wow.
so it's not even a matter of like you have to deal with it one time. It's that the same businesses could be hit multiple times from different firms representing different people at the same time. So, unless we get more courts to come to a clear, consistent sort of set of decisions that, and specifically ones, that say that this law doesn't apply to IP addresses or internet communications or website use. I think you're going to see more of this. The only other potential X factor is the California legislature getting involved and amending the law, like passing an amendment to the law, making it really clear that it does or doesn't apply. But absent something like that, it's just going to
Yeah.
be, fought through the judicial system.
Yeah, because it's a money-making thing now. I mean, for businesses that haven't been sued yet, haven't gotten the demand letter, is there anything that they can do to minimize the risk of getting sued?
Yeah, I think it comes back to just responsible data policies and practices. Knowing what's on your website, knowing what, people visiting are consenting to, what type of data are you collecting, how are you collecting it, what are you doing with it? Is your privacy notice, accurate, comprehensive, and does it actually reflect what you're actually doing on your website? I think those are, general things that can be done proactively to try to minimize the likelihood that you're going to be hit with the lawsuit. And then also, like I talked a little bit about chat bots, if you have a chat bot, like you might be hit with a CIPA violation related to a wiretapping claim. So if you have that, you may want to assess, do we need that? Do we want that? I think those are really the things you can do, but at the same time, you just have to be aware that you may just kind of get pulled into this. And so it's not just a matter of, as long as I have my ducks in a row and I'm doing what I think is right, like I can never be sued. Like that's not necessarily true.
Yeah, I think we see a lot of businesses who, maybe 5 years ago they were running ads on Facebook and they have the Meta Pixel installed. They ran the ads. Maybe the ads weren't as fruitful as they thought they were. And they've kept this pixel on the site, even though they're never going to run ads again. Remove stuff like that from your website because number one, it's not benefiting you or your business in any
Hmm.
way. And number two, it's putting you at risk.
Yeah, 100%. I mean, you should know, it's just what privacy by design, data minimization, those types of, basic principles. Just knowing what you're collecting, what you're doing. Do you really need it? And if you don't, like, don't have it. Relatedly, and it's a little bit different, but another thing to consider is insurance. A lot of companies are getting insurance that could extend beyond just the data breach and could extend to alleged violations of CIPA. So that's another thing that I know a lot of people in the space are looking at more closely.
What about like obtaining the consent of a user from California before tracking them?
Yeah, that's another thing that they should really consider doing, and that's something that I think it'll minimize or it'll decrease the risk of being sued, but you'll oftentimes see people who have those types of banner ads, banners on, they're still getting a letter or they're still getting sued. And
Mhm.
what can be difficult is that, whether that banner worked and worked properly and was always in place and all that sort of stuff can sometimes be considered what we call a question of fact, which means that ultimately a judge or a jury after discovery would have to determine whether, you know, consent was proper. And so it could result in a situation where, as a business, you think you're doing what's right, you get sued, and it's only after litigating it for a while that you prevail. And again, going back to what we talked about before, sometimes it'll just be a matter of like, we think we did everything right, but it's cheaper and more effective to just settle and get out of this now rather than try to get to a point where we're arguing about or proving that our the consent was actually obtained properly.
Yeah, I think it also depends on the banner design that you have or the company
Yeah.
that you use because there's a lot of them out there that are like, we're tracking you with cookies and we're assuming that's okay. So they fire the metapixel without consent and then the user can
Hmm.
opt out, which wouldn't be applicable under CIPA because under CIPA, it can fire only after the user has consented.
Yeah, and that's those types of questions of like how long has that banner worked or what kind of banner do you have? That's when you get into, like I said, questions of fact, and that's when you're really litigating issues and fighting over the evidence versus trying to resolve a dispute, you know, in the earliest phases of the case.
Yeah. So, if a business wants to speak to you about retaining your services for help with a SIPA demand letter or SIPA lawsuit, where can they reach you?
Yeah, they can find me online. My email, jason at annagueymccann.com. I'm also on LinkedIn, linkedin.com/IN, Jason Y. Kelly. You also could just Google me, Jason, middle initial Y, Kelly. That's the easiest way to get a hold of me.
Awesome. Well, Jason, thank you so much for taking the time to speak with me today about the California Invasion of Privacy Act. To our listeners, please make sure to subscribe to our podcast so that you don't miss the next episode.